The information discussed in this presentation is current as of the date noted and is for informational purposes only and does not intend to address the financial objectives, situation, or specific needs of any individual investor. Any information is for illustrative purposes only and is not intended to serve as investment, tax, or legal advice, since the availability and effectiveness of any strategy is dependent upon your individual facts and circumstances. Results will vary, and no suggestion is made about how any specific solution or strategy will perform in reality.
So here we are. We're going to talk estate planning today. Now, a couple of things to make you aware of. First of all, estate planning as a topic of discussion can be it can be dark and dreary, as I said. So I may try to lighten it up with some really bad jokes, but I'll keep those at a minimum. Also, what you should know is that neither Derek nor I are attorneys. And so that may come as a surprise. Why are two non-attorneys addressing the sensitive topic of estate planning when we often view it as very legal based? We don't even play attorneys on TV. So, but that doesn't mean that we shouldn't talk about it as advisors. We often get many questions from our clients just by nature of the relationships we have with our clients. They're very comprehensive, and estate planning is a priority overall when we think about the whole lifespan of our personal finances. So we often get many questions around, should I have a will and how should it be structured, or should I put something in a will, or should I put it in my power of attorney? Do I need a trust to do something? Do I put my house in a trust? How should I own a certain asset? How should I structure my beneficiaries? So as you can see, these types of questions can cause a lot of confusion. And as advisors that, as Ryan said, pretty much get involved in just about anything your money touches, estate planning is one of those important areas. So we're going to cover a lot of topics today. And I think Derek and I, as non-attorneys, have over our time here and working with clients have developed a way to address this topic in a fashion that brings this down to a base level that we can all understand. I remember when I first started in this business, estate planning was probably my least favorite topic, because I'd rather, and I know Derek's the same way, we'd rather talk to our clients about how to save and spend their money versus what should be done with it upon our passing. That doesn't sound as fun as a conversation. So, but I think we've established a way to address these topics. And the first thing we should do really is define what estate planning is. So Derek, why don't you take us through just defining what this is so we understand what we're talking about today?
Yeah, Jason, this is a very common question asked. So what even is estate planning? Think of it as the process of organizing your wishes and final affairs. These final affairs can include assets, which could be bank accounts, retirement accounts, your property, which could be your home, your vehicle, and even medical care and dependent care. We can use specific documents to accomplish these wishes. We want to make sure that we take care of the sensitive issues that I just listed, because this can help relieve stress not only on you, but your family members. This is why it's important, and a great segue into the next slide, as Jason will explain, why is it important, as I just kind of touched upon a little bit in my slide.
Yeah, so now that we know what estate planning is, let's dive into why it's important. Well, as I had mentioned, we get into a lot of questions about what people need to have. And Derek touched on it, that without a plan in place, we leave our family, our loved ones, our friends, really with no guidance as to what our wishes are if we don't establish a plan in the first place. This isn't always done through legal documents, but they tend to be the foundation for our planning as we think about wills and trusts. But if we don't have some of these basic documents and we haven't communicated a plan or given any guidance or direction to our loved ones and to our friends who will have to ultimately deal with us upon our death. Remember, our estate plan is really for the person who's got to manage it. It's not really anything we're going to be involved in. We're sort of dead and gone. So we need to leave this to that next person to deal with. And if we don't do that effectively, think of what we've just piled on top of our family, friends, and loved ones. In addition to the emotional toll that losing a person takes on us, we also would then have to try to guess what their wishes are, or possibly even if there isn't legal documents in place, the state may come in and dictate some of that, and we're leaving that to that next person to deal with, working with the state, working with the rest of the family or loved ones or other beneficiaries as to what may have wanted to occur but was not well laid out in advance. So with that, let's jump right in. Derek and I, like I said before, we think we've boiled this down to sort of 4 commonalities around estate planning that Derek's going to walk us through, and then we're going to dive into each one a little bit, right, Derek?
Yep. So in this presentation, we have a nice graphic that lists the 4 common ways we can leave assets. In the estate planning process, you may use 1, 2, or even all 4 of these, but there is truly no one-size-fits-all to this estate planning approach. And in the next slide that I'm going to be presenting, I'm going to be going over one of the more common ones, which is the will. The next slide. Basic understanding of the will. The will is just a legal document that outlines how you want your assets and property to be distributed upon your death. Now, there are some key components within the will. You have your executor. This is the person who will carry out the instructions listed in the will. Then you have your beneficiaries. Your beneficiaries are the people that are named inside the will that will receive these assets. Then you have the guardian. The guardian is the person legally responsible for care of another person, which could be a child or a minor. Essentially, everyone is more than likely going to need a will, but a will does not avoid probate. It is essentially just lets the judge know what your wishes are. Probate, which is another buzzword that is often thrown around in this conversation, it's just a legal process. It's judges, it's lawyers, it's the court systems. Probate can be very costly and time-consuming. Avoiding the probate process is simple to do with other estate planning methods that we'll be describing later on in this presentation. One of those is a trust, and in the next slide, Jason will go into how a trust can avoid probate.
That's right, Derek. I think, one of the key points you hit is just about everyone will have a will, but not everyone's necessarily going to have a trust. When we think about how we start to build our estate plan, we think of a will or a trust or both. And where we start to bring trust into this conversation is maybe where we start to develop some confusion in what they are, because we see all these different names of trusts. And what do those names mean? Well, first of all, what we need to understand is that there's really only 2 types of trusts. There's revocable and irrevocable. And revocable trusts are just that. They can be revoked. They can be changed. Irrevocable means you cannot change them. They cannot be undone. So we often talk to clients when we're talking about irrevocable trusts, they need to make sure that this is something they're definitely dedicated to because it cannot be undone. However, revocable trusts are a pretty common structural format for an estate plan. It can be the basis upon which the rest of the plan is built, where we put everything into a revocable living trust, and we'll talk about what that means in a moment. But what we also need to have, if we go down this structural path of a revocable living trust, as Derek said, we also need a will coupled with that. And the reason is because something that Derek's going to come back to later, if there are accounts that don't get retitled into the name of the revocable trust that should have been, a will simply might say, hey, anything that's in my name upon my passing, put it over there into that trust I developed. I left this one out by accident. Okay. So what does a revocable trust do? Well, it essentially is a way to add beneficiaries to assets. And we're going to come back and talk about beneficiaries specifically next, but let's spend a little more time on trust, is when we get the question of, should I put my house in trust? Should I put this account in trust? Really what we're doing is we are assigning beneficiaries to those assets and providing direction to the trustee what should happen next upon our passing. Now, we might use a revocable living trust while we're alive, and we may be even the trustee of that trust, and that's okay. It allows us to do whatever we want with the trust or whatever's within the trust. And then upon our passing, typically what you'll see is it becomes irrevocable, and we appoint another trustee. And then their job is to follow our direction or guidance that we built into the trust when we first established it. So now you're hearing a couple of key terms that are relevant to trust. There are trustees. Who are the trustees? Well, these are the people that are charged with managing the assets of the trust and what is provided in terms of guidance of the trust. You may be your own trustee while you're alive, but then upon your passing, you're likely to appoint someone else to assume that role to finish out whatever guidance is inside that trust. And then there are beneficiaries. These are just the people that are going to receive income or assets from the trust. And it could be you. You could be the beneficiary of your own living trust. And then upon your passing, it would be something else. Now, beyond that, there's a lot of terms and uses for these types of trust. And you're going to see some more of those examples in your booklet that we've provided. But let's talk about a couple. We might have a trust built into our estate plan, whether it's inside a will or inside a living trust that we developed for minors. Let's say they're our children or our grandchildren. We might establish that trust so that they get income from the trust to help support them while they're growing up, but then at certain points in their life, they get principal distributions from this trust. All this is an irrevocable trust that has come from some other place, whether it's assets passing from the will or from the trust. You may hear other uses for trust, like should I put a property in a trust so that I can use this property while I'm alive, but then it passes to my children upon my death. Again, that could just start out as a revocable trust that we've established so we can move the property in and out of it, but then upon our passing it becomes irrevocable, even if it's only irrevocable for a short period of time, just to pass the property out to our ultimate beneficiaries. So like I said, trusts can be the foundation for your overall estate plan, which you would still need a will for to make sure that anything that didn't end up in the trust is poured in there, or it can provide guidance down the road beyond our passing as to who's to receive these assets or at what time they might receive these assets. Now, here's the other benefit of a trust-based structure. As Derek said and pointed out, anything that looks to a will as to where it goes next goes through probate. Anything that looks to a trust document does not go through probate. So a lot of people establish a trust-based estate plan so they avoid the probate process. And therefore, then it's much more private. It's not something that has to go through the court system. So with that, as I had mentioned before, we're going to talk more about beneficiaries. They're a key part of a will. They're a key part of a trust. But Derek, how else can we use beneficiaries in our estate plan?
Yeah, those are all great points you touched upon, Jason. Another common way that we can leave our assets is through designating beneficiaries. Designating a beneficiary on your retirement accounts will avoid probate. Setting up bank accounts, as commonly termed you might have heard of before as payable on death or POD. Changing your individual brokerage account to transfer on death, TOD. These are all methods that can establish a beneficiary on those accounts and avoid that probate process. With that said, though, listing beneficiaries on these accounts will bypass what is written in a will. This is a very common misconception when talking about this topic. How your accounts are titled will overrule what is written in your will. It is important to check and make sure that your wishes in each of these, whether it's a will or your account, are in line with each other. Reviewing your listed beneficiaries between your will and your accounts is a key part in the estate planning process that us financial advisors always go through with our clients. In the next slide, another common way is through ownership on these accounts.
That's right, Derek. Great points. Now, just so in case you're keeping score, remember we had the one slide that we said there are 4 common ways to really build an estate plan, and you may use one, you may use all of them, or somewhere in between. We're on number 4 right now. We've covered will, we've covered trust. Derek just covered beneficiaries. Now we're going to talk about how you own your assets is also a part of an estate plan. And so we think about this, and we don't tend to think about beyond an individual ownership or maybe a joint ownership very much. So, but there are certainly other ways we can own assets that will impact the estate plan. And again, as Derek just said, the way you own an asset or an account may determine whether it looks to a will or a trust for the next place that it moves to. So let's move through these. If you own an account or an asset individually, that's going to have to look to your will as to where it goes next, unless you've assigned beneficiaries, as Derek just said you can do. So it would look at ownership first, beneficiary second. And if you have an individual account, let's just take your bank account. You own a bank account individually and you haven't assigned beneficiaries, then it's going to look for a will to determine where it goes next. And if you have no will, then it says, hey, state that I live in, where should it go next? And that's what we're trying to avoid. Okay, let's move on. JTWROS. You may have seen this acronym actually if you own any accounts jointly, say with a spouse. And what this stands for is joint with right of survivorship, JTWROS. This is the first line of estate planning. If I own an account jointly with my spouse, upon my passing, it all becomes hers. Upon her passing, it all becomes mine. Now, where we need to follow up with an effective plan is what happens upon the second of us to pass away. Are there beneficiaries already listed that says here's where it goes to next? Or does it have to look at our will? Now, remember, these beneficiaries can actually be a trust. Okay, we just covered the trusts. We may already assign assets into a trust when we first establish it, but you can own an account outside of a trust and say the beneficiary is my trust upon my passing. Okay, so joint with the right of survivorship just means that the survivor of the joint of the one owner inherits the whole thing. Now, what the heck is JTIC? JTIC. This is another form of joint ownership. It stands for Joint Tenants in Common. You may have also seen it as JTC. Joint Tenants in Common is essentially, you want to think of that as percentage ownership. If Derek and I go out and buy a piece of land together because we like to hunt or something, and we own it joint tenants in common, I own 50%, Derek owns 50%. But upon my passing, my 50% doesn't automatically go to Derek like joint right of survivorship does. It would then look to my estate plan as to where it would go. Okay, so joint tenants in common isn't an automatic inheritance like joint right of survivorship. And then there are just other entities we can own things in. We may think about LLCs as an example. Those of us who own maybe rental properties or investment properties, we might own that inside an LLC. You can utilize that LLC structure as an effective way to pass that property on, or you're essentially passing the shares of the business on to someone else. It could be written into the operating agreement. Now, I've had questions before is, should I have a trust that owns my LLC? You certainly can do that. If you haven't established the next ownership inside the LLC operating agreement, you may want to re-register the ownership of the LLC inside a trust to then look to the trust as to what happens next. So you can see just by purely owning something in the right way, and maybe even coupling it with the beneficiaries that Derek just talked about, we can establish a plan or guidance or direction for what should happen to those assets upon our passing. And we can go to the next slide. Any estate planning discussion is not complete until we talk about taxation. I mean, how much fun are we having today? We're talking about the two certainties in life, death and taxes. However, when it comes to estate tax and inheritance tax and gift tax, there's no guarantee we're going to have to pay those. There's certainly a guarantee we'll pay taxes in other places. So let's take a few moments, just cover these at a very top level, because the thing that we need to pay attention to is at the end of 2025, there may be a change in the federal estate tax system and maybe the states as well. Okay, so the four main areas of tax that we might pay as a part of this discussion: federal estate tax. Right now, all of us have a lifetime exemption amount of roughly $13 million. And what that says is we can pass $13 million upon our death to a non-spouse, and the estate will pay no tax with it. Okay, I can leave as much as I want to my spouse. I'm not limited to 13 million, but I can pass 13 million to anyone else. Okay, now my spouse would also get the same 13 million. And then there is another carve out in the federal estate tax law that allows us to share each other's 13 million. Meaning if I pass away and I pass everything to my wife, an estate tax return can be filed that says, hey, Jason's dead. He gives in addition to the asset, Jason gives his wife his estate tax exemption of 13 million. So now she's got 26 million. And I wish we had that problem, but we don't. And that's the whole design of the federal estate tax, is to exempt many of the states in the country from federal estate tax. Okay. Now, beyond the federal estate tax, we could have a state estate tax. Say that 10 times real fast. And New York, where we're sitting now, is actually one of those states. They have their own estate tax. And it's similar to federal, but not exactly the same. So with New York, we have a $7 million, roughly $7 million exemption where we can leave any non-spouse $7 million tax-free. The one difference between, in addition to the amount from the federal estate tax, is that we don't get to share between spouses. Remember, I can pass my 13 million of federal exemption onto my spouse. In New York, I cannot pass my $7 million exemption onto my spouse. So effective estate planning is crucial if you're dealing with estates at that level. Beyond that, with the state estate tax, I'm going to hit the pause button there because there is some additional planning and tax differences between the state and federal. And if you've heard of the New York State estate tax cliff, that is a real thing. It means when you get to a certain amount in New York, the whole estate is taxable. You don't get the 7 million exemption even. Okay, then you can have a state inheritance tax. This means that it's not paid by the estate, but by the people inheriting the estate. And our neighbor to our south, Pennsylvania, has, guess what, an inheritance tax. Now, it doesn't matter if the beneficiary itself lives in Pennsylvania or somewhere else. It's where the person's estate is, where they're deemed. So if I consider myself a Pennsylvania resident and I pass away, but I have a child in Maryland and a child in California, let's say, they would pay the Pennsylvania inheritance tax, even though they don't live here. It's because I lived in Pennsylvania and my estate was located there. Okay. And then the fourth one is a gift tax. And really what the gift tax is it couples with the federal estate tax or the state estate tax. Now, many of us know that we have an annual gift limit. Every year we can gift a non-spouse $18,000, and that's been less than that, and it usually goes up with inflation. But this year it's $18,000, and I can give one of my children $18,000, and my wife can give one of our children $18,000 for a combined $36,000. And if that child is married, we can double that even if we want to give money to that spouse. So we could essentially give $72,000 for my wife and I to our child and their spouse. That's essentially gift tax. There is a limit. Once we go above that, it doesn't mean that we're going to then start paying tax on those gifts. This is where it ties to the federal estate tax. It means that we have to file a gift tax return that says we went beyond our annual gift amount that is essentially free and clear, and we're going to start using our federal estate limit of $13 million. Okay, that's all that means. Now, in New York State, you might say, well, does that do the same thing in New York State? Do you have to report that? And does it come off your 7 million? The answer is no. New York State currently does not have a gift tax. So New York State doesn't care how much you give, but the federal government does. So we're going to finish our tax conversation right there. And certainly we can address questions if there are any, but just know that there are some pretty high limits that we would have to start considering if we're going to pay federal or state taxes on our estate in some way. So all of this can be incredibly overwhelming. And we've just provided a bunch of technical information to you. And we understand that sometimes it's kind of hard to connect that down to our specific situations. So Derek and I are going to attempt to do just that. If we didn't already kill you with a lot of technical jargon, and that's one of those bad jokes, if you're still alive and listening to this, then let's get into some specific examples as to how we apply some of what we're talking about in real life. Derek, why don't you start off?
So where should I put charitable bequests in my estate plan? This is a great question, and in the next slide, I will go into some strategies we can use in implementing that. So they could be listed directly in your will or trust. We want to make sure that we include full legal names when doing this. When listing them, think about giving them in the amounts of percentages rather than round dollar figures. This can make the process a lot more efficient, as if you have a lot of beneficiaries listed, the percentage method does guarantee them each a slice of the pie at the end. When you leave money to charities in your trust, one step that is often forgotten is to retitle your accounts and to fund the trust in the trust's name. So when going through the trust process, there's really two steps. There's creating the trust, which the attorneys do. Then there's funding it. In the funding it process, we need to, as Jason went through in one of the last slides, was ownership. We do need to go in and retitle these accounts so that the trust can be funded. This is often a step that is forgotten in the process. Then there's beneficiaries on IRAs or other qualified plans. There's tax benefits for leaving an IRA to charity. Taxes will not have to be paid on the money in the account when left for a charity, and that's another great strategy if you're looking to implement that into your estate plan. The next slide, me and Jason will go into more specific examples with our fake couple, Bill and Penny.
That's right. In order to really drive some of these points home, we've created a fictional couple, but out of real life conversations that we've had in the past, bringing you some real live examples. So you might be able to connect with something that we're going to talk about here. So meet Bill and Penny. They are our fictional clients that have one of their top priorities, estate planning. So we started to go through some of the key aspects of their estate and their financial lives to pick apart some of the things, and maybe some of the pitfalls and some of the options we might have for them in their estate plan process. So let's move to the next slide. And we're going to start with real estate. Why not, right? This is often one of the biggest question areas we get is how do we deal with real estate? Well, Bill and Penny, they have their primary residence located in the state of New York, and it's jointly owned. So right there, we're already partway into estate planning, right? We just talked about how ownership is an effective part of a complete estate plan, where that upon the first of them to pass, the other is going to inherit that home, and they live in the state of New York. But Bill and Penny share with us also that they have a second home in Florida that's also owned jointly. So again, we're partway down the process of estate planning for the second home in Florida, because upon the first of them to pass, the second will automatically inherit it. We don't need to look to a will or a trust or anything to decide where that goes next. However, we have one very key issue now that we've just pointed out, which is they have real property in two different states. So our common suggestion in this scenario, and it's not an every scenario suggestion, but something that we might talk about with Bill and Penny, is consider placing the Florida home in a revocable living trust. Now, why do we pick on the Florida home? Well, they've already established that New York is their state of domicile. So that's important. That's where their estate will be taxed or will go through probate or whatever. But if they have this real property in Florida and they just own it jointly, upon the second of them to pass, they'll also go through probate in the state of Florida, and that's because it's real property. It's called ancillary probate. So how do we avoid that? Well, certainly upon the first of them to die, we've avoided that. It just automatically goes to the spouse. But what if they're traveling together and go and pass due to common disaster? We want to have that protection already in place. So we would recommend potentially putting that into a revocable living trust, which would say, this is our trust, we're the trustees. Upon our passing, here's what happens next.
Bank accounts that they have are owned jointly. Now, jointly owned bank accounts, first question would be, have we thought of possibly designating beneficiaries? In the example that I had talked about earlier through payable on death, that is a great method to accomplish titling that account to not have to go through the probate process. But there is an except, as we'll see in the next slide as well. Bill owns an individual account with about $50,000 in it for a special family vacation he's planning for Penny and their adult kids. Now, the account is titled individually in Bill's name, and now that account, upon Bill's death, would go through the probate process if left untouched. Now, like I had mentioned in the last example as well with the joint accounts, have we thought of maybe at least titling it jointly or going through the payable on death method to make sure that that money does not go through the probate process? Same with various retirement accounts that have each other listed as the primary beneficiary. You can list contingent beneficiaries. So if there is anything to happen to you or your spouse, there is a backup that is put in plan to make sure we do avoid that probate process if that's important on your list to do in the estate planning process. Life insurance, Jason will cover next.
Yeah, before I jump into life insurance, Derek, I think you made a great point on retirement accounts. We often see where there's only one beneficiary listed and no contingents. So that would be step number one. But another question we get when we're building this entire plan, again, we might be using a will, a trust, beneficiaries, or all of them, is, well, let's retitle the retirement accounts into the name of the trust. And that's a no-no. We cannot retitle retirement accounts. They have to be owned by a person. They have to be owned by the person who owns that account. And so we need to, if we're going to build a trust structure in, that trust A needs to be written very carefully to handle retirement distributions, and the beneficiaries need to be structured accurately to the trust. And so another place a contingent beneficiary may come in, it may be a trust, as long as the trust is written correctly. So now let's jump to life insurance, right? So now they each have a life insurance policy, and they're each listed as a primary beneficiary. So most of you are probably thinking from the discussion on the retirement accounts, hey, we already caught the issue here. We should be listing a contingent beneficiary. And that is probably true. Life insurance is actually a little more flexible than retirement accounts. You see, we don't have this tax qualification status like retirement accounts have, so maybe we're a little less concerned with the taxability going forward upon our passing. With a life insurance product, life insurance can be owned by a trust. It can be owned by another person. Even though we might be the insured, I might be the insured on a policy, but my wife might own the policy, then that policy is taken out of my estate and put into hers as she is the owner. I'm just the life that it's insuring. So I have no real claim to any of that value. But we certainly can look at contingent beneficiaries. And then the question we get is, who should be the ultimate beneficiary? Because as I said, these don't have the same nuances as retirement accounts do. Sometimes I've seen attorneys recommend that beneficiaries of life insurance be left to an estate, meaning it'll drop into the estate. And why would we do that instead of having it go right to a person? Well, if an estate needs liquidity, if it needs cash to settle final expenses or something, sometimes that can be created through life insurance proceeds. And we know the life insurance claim process is pretty quick. Usually it's simple as a form and a death certificate, and it can get to whoever that beneficiary is fairly quickly. So if we do need liquidity inside an estate, that could be a recommendation from an attorney, and that's where it should really come from. Or we leave it to a person, and it moves pretty quickly, as I said.
Yeah, that's a great point that Jason just pointed out. Retirement accounts cannot be in any other person's name besides yourself. So you cannot go into a retirement account and title it into a trust. But that leaves the avenue open for investment accounts. Investment accounts are a great way to fund a trust. And in this example, we would require the account to be changed from jointly to the name of the trust. So this is kind of the way that you would, if you want to fund the trust, the two-step process, create it and fund it, it would be through some sort of investment account vehicle like your individual or jointly owned brokerage account. The next point, old wills, Jason will touch upon that example. Oh, Jason, you're muted.
Thank you, Derek. So with old wills, as I was saying, Bill and Penny, we've discovered they have old wills. They appoint each other as executors. They list each other as primary beneficiaries and kids as contingent beneficiaries. And this is a pretty common setup, and that's okay. A couple of the key points we want to consider here is really around the kids. Now, the wills we would want to have reviewed by an attorney to make sure that if they are really old, do they need to be updated to some current state law, because there might be some additional language that needs to be built in there. But really, it's around the kids that we would focus on, is how old are those kids? Now, we've established that they're adult children, whatever that means, because Bill's planning some big vacation for the whole family, which is wonderful. But now we might start to consider, if we know that, where should the kids start filling roles as maybe backup executors to mom and dad in the wills? Because now they're old enough. Certainly as beneficiaries, maybe they're okay with the kids inheriting those assets directly, or they can be adults and still be 21 years old, and maybe they don't want their children to inherit a bunch of money at the age of 21. They would prefer to structure a trust within the will that says upon if my spouse has predeceased me, then it goes into trust for my children to use to pay for education and support themselves. But I don't want them getting big chunks of dough at the age of 21, and maybe they set it up where they get a chunk at 25 and another chunk at 30 and another chunk at 35, which is what we see often. So this brings up another point where how we're utilizing many of those four commonalities that we talked about. In this situation, we may use a trust inside a will to establish a form of inheritance that spreads out to when we think our kids might be more mature. But we're also reconsidering the roles that everybody plays within the estate plan, and maybe it's time for our kids to step up and be at least maybe backups in these situations. Okay, now sort of putting aside the estate planning for a moment, a couple of other documents, they're often called ancillary documents that are brought up as a part of the estate planning process. With the estate planning process, we're talking wills and trusts, and these are all effective upon our passing, but these ancillary documents are effective as soon as we sign them, so they're while we're alive. And the common ones we talk about are powers of attorney and healthcare related documents like a healthcare proxy and HIPAA forms. So let's talk about it really briefly what these are. The powers of attorney, this is the financial document. It's what assigns authority to someone else to handle our financial affairs when we cannot do that for ourselves. And it doesn't have to be because we're in a coma or we're just medically unavailable, but it can also be when we're just not around, right? So we're off on some big trip and we need a power of attorney to pay a bill for us or transfer some money or something like that. So it's a very powerful document. Again, there's ways to structure it so it is a springing document where it only comes into play when under certain conditions. But a lot of attorneys will say, listen, if you trust this person to handle it at that point in time, why don't you trust them in their entirety? So there's certain things to consider, but if it's just a normal durable power of attorney, it's effective essentially right away. And so you keep that under lock and key. You don't necessarily hand that out. Now with the healthcare related documents like healthcare proxy and HIPAA forms, these are the folks that we joke, this is the person you assign to pull the plug when you can't make that decision yourself. And the healthcare proxy is the document that gives them the power to do it. The HIPAA forms or HIPAA language inside these documents is the part of it that says, here's who can get the information to make decisions if they're in that. So you actually may have a long list of people that can get health information about you, but you may have a very short list of who you're giving the decision-making authority to. So these are often wrapped into the whole estate planning process when you are working with an attorney, with an advisor to get this in place. And we often recommend that even if you've got something old in place, the laws, the language, the rules around these change frequently as well. So we often say if you're going to go do a rework of the will or the trust or both, go ahead and rework these and get them up to date as well.
So, why are two financial advisors talking about estate planning? As Jason mentioned earlier in the presentation, both me and him are not practicing attorneys, but as financial advisors, more often than not, we will have a longer relationship with you as a client than an attorney would. We will have a much better understanding of your overall financial situation and picture. We as your advisor like to have a 30,000-foot view on your estate planning. We can help clients get through this process by having these in-depth conversations like we are now before going to even seeing an attorney to draft these documents. Our goal is to save you time, money, and stress that comes along with it. As your advisor, we look to not only invest, grow, spend, but eventually pass on your nest egg.